Hello, my name is Eliza Meekings, and today I will be presenting on the topic of migrant worker rights and capital punishment. So, it is a truth universally acknowledged that a state in possession of independent sovereignty must be in want of governing their territory and peoples in accordance with their own laws. However, I will be talking about today when the enforcements of these laws are in regards to migrants and what rights they are owed by international conventions. So we're going to start off with a little bit of background information. Then we're going to go to relevant international conventions. Then we're going to look at two case studies and do a comparative analysis of both. And then we'll conclude with some key takeaways and developments. So, capital punishment stems from the idea of punitive justice. Punitive justice stems from the deontological branch of ethics that outlines the theory of retribution as justifying the enforcement of laws by dictating that an offender must pay their debt to society through suffering. To conform with Article 6, subsection 2 of the International Convention on Civil and Political Rights, the ICCPR, retentionist jurisdictions must impose the death penalty only for the most serious of crimes. Now, what constitutes the most serious of crimes is both culturally and historically contingent, but for the purpose of narrowing the broad issue in this presentation, it is not contentious that murder qualifies as a most serious crime. To be able to execute the sentence of capital punishment at an international standard, the penalty can only be carried out pursuant to a final judgment rendered by a competent court. Now, we're going to discuss how I'm going to narrow the scope of this research. So we're going to focus on the Gulf states. This is because the European Saudi Organization for Human Rights and other civil society organizations have recently compiled extensive research demonstrating that death sentences and executions have taken place in the context of systematic and egregious human rights violations. Just as a disclaimer, this is in no way to say or infer that similar violations do not occur outside the Gulf states context. This is just what we're focusing on. We're also going to be focusing on female domestic workers. Due to the work of legal feminist Catherine McKinnon, we can see that the intersectionality between gender and migrant workers can sometimes mean the harm of the ends is not necessarily the harm of the means. This is also not to say that male migrant workers don't also face these violations of the human rights, but we're focusing on female migrant workers because usually they're contractually obliged to stay within the sphere of the home while they're posted abroad, and therefore cannot create relations outside of that home that can support them in the circumstances that they're detained. Our relevant international conventions, as you can see on the screen, are the Vienna Convention on Consular Relations and the Convention for the Protection of All Migrant Workers and Their Family Members. The Vienna Convention on Consular Relations is a grounding doctrine for the more modern International Convention on the Protection of the Rights of All Migrant Workers and Members of Their Families. However, unlike the latter convention, which is sparsely ratified, the former convention has been ratified by 167 nation states, including the Arab Gulf states. This is why we're going to be focusing on the right of Article 36 under the Vienna Conventions on Consular Relations. This article exists to ensure that the consular authorities are able to assist the detainee by not only providing access to competent counsel and additionally assisting with the investigation of the case, but also by intervening in the trials where due process rights are breached. As we should be able to recall, you can only, on an international scale, legitimately carry out the penalty of the death penalty on a migrant worker if it's pursuant to final judgment rendered by a competent court. Article 36 ensures not only legal representation and advocacy, but also that the court is at competent standards. Now we're going to look at some case studies. As a head up, the cases discussed include content that may be upsetting for some people, so please do keep this in mind as we continue with the presentation. This is Tuti Tursilawati. Tursilawati was an Indonesian woman working as a domestic worker in Saudi Arabia. During her employment, she was repeatedly sexually assaulted, and this culminated in her killing her employer in an act of self-defense as he tried to rape her. She was subsequently apprehended and in this process gang raped and then sentenced and executed without notification being given to the Republic of Indonesia's government. Here we can see that her case highlights the complicity of law in ignoring the physiological and social power differences between men and women, and this context has put Trisilawati in a more vulnerable position than other male counterparts. Because her rights under Article 36 were not exercised, she was unable to plead mitigating factors in an appeal. On the other side, we have Raifer Delquez, who was a Filipino domestic worker. She was based in the United Arab Emirates. In 2014, similar to Tutsilawati, Delquez killed her male employer in an act of self-defense when he tried to rape her, and she, like Tutsilawati, received a death sentence. However, under Article 36 of the VCCR, she received her due rights. As a result, she could successfully appeal her sentence, and it was commuted to 5 years of incarceration. She returned home in 2018. Because she had access to her consular support, she was able to plead her mitigating factors and was able to get her sentence commuted. So these two cases, they are near identical in crime and context, but they resulted in vastly different sentences being carried out, and that arguably is at least in part due to the individual's rights under international law, Article 36 of the VCCR, being respected. It would be a valid argument had Delquez originated from a country with a markedly lower level of remittance than Tutsilawati, as this could have been grounds for her counsel to have been able to take action where Tutsilawati's may have failed due to workload. However, as it stands, both the Philippines and Indonesia have similarly high levels of remittance. In fact, the Philippines has a higher level than Indonesia. Hence, this reinforces the importance of the receiving country to notify the sending country of their nationals' detention so that their rights may be exercised. So, in conclusion, I would advocate for a universalist approach to be taken to ensure more consistency in regards to the application of international human rights law. This would respect the ratification status of individual states whilst acknowledging the intrinsic rights of the individuals. This is because the transnational nature of migrant work creates an interstitial relationship between sending and receiving states, necessitating the consistent application of international human rights standards. Secondly, we can see developments in the institutions of the different states. Because of the struggles faced by remittent state workers abroad when seeking access to justice, in recent years there have been steps to create institutions like the proposed Department of Migration Development in the Philippines. This would share the onus of ensuring the individual's rights under international convention is met between the sending and receiving states. Such developments have gained momentum in recent years as workers continue to receive capital punishment in the Gulf states without being granted their due rights. Thank you very much for your time. I hope I've given you some things to consider on this topic, and if you have any questions, I would love to hear from you.